Greetings. I'm going to give you today 7 elements of jurisdiction. Number 1, the accused must be properly identified. Identified in such a fashion there is no room for mistaken identity. The individual must be singled out from all others. Otherwise, anyone could be subject to arrest and trial without benefit of wrong party. Defense. Almost always, the means of identification is a person's proper name, but any means of identification is equally valid if said means differentiates the accused without doubt. There is no constitutionally valid requirement for you to identify yourself. See the Fourth Amendment. Also see Brown versus Texas, 443 U.S. 47, and Colender versus Lawson, 461 U.S. 352. Number 2, 7 elements of a jurisdiction. The statutes of the offense must be identified by its proper or common name. A number is insufficient today. A citizen may stand in jeopardy of a criminal sanction for alleged violation of statutes, regulations, or even low-level bureaucratic orders. Example, Colorado National Monument Superintendent orders regarding an unleashed dog or a dog defecating on a trail. If a number were to be deemed sufficient, government could bring new and different charges at any time by alleging clerical error. For any act to be triable as an offense, it must be declared to be a crime. Charges must negate any exception forming part of the statutory definition of an offense. By affirmative non-applicability, in other words, any charge must affirmatively negate any exception found in the law. Number 3, the act of alleged offenses must be described in non-procedural language and detail so as to enable a person of average intelligence to understand nature of charge, to enable preparation of defense. The actual act or acts constituting the offense complained of. The charge must not be described by parroting the statute, not by the language of same. The naming of the acts of the offense describe a specific offense, whereas the verbiage of a statute describes only a general class of offense. Facts must be stated. Conclusions cannot be considered in the determination of probable cause. The accuser must be named. He, she may be an officer or a third party, but some positively identifiable person, human being, must accuse. Some certain person must take responsibility for the making of the accusation, not an agency or an institution. This is the only valid means by which a citizen may begin to face his accuser. Also, the injured party, corpus delicti, must make the accusation. Hearsay evidence may not be provided. Anyone else testifying that they heard that another party was injured does not qualify as direct evidence. Number 5, the accusation must be made under penalties of perjury. If perjury cannot reach the accuser, there is no accusation. Otherwise, anyone may cause another falsely without risk. Accuse another falsely without risk. Number 6, to comply with the 5 elements above, that is, for the accusation to be valid, the accused must be accorded due process of law. Accuser must have compiled with law, procedure, and form in bringing the charge. This includes court-determined probable cause, summons and notice procedure. If lawful process may be abrogated in placing a citizen in jeopardy, then any means may be utilized to deprive a man of his freedom, and all dissent may be stifled by utilization of defective process. The essential elements of due process are not, the essential element of due process are notice and opportunity to defend. Simmons versus Kraft, 182 U.S. 427. One is not entitled to protection unless he has reasonable cause to apprehend danger from a direct answer. The mere assertion of a privilege does not immunize him. The court must determine whether his refusal is justified and may require that he is mistaken in his refusal. Hoffman versus United States, 341 U.S. 479, 1951. Number 7. The court must be one of competent jurisdiction. To have valid process, the tribunal must be a creature of its constitution, in accordance with the law of its creation, i.e., Article 3, judges. Lacking any of the 7 elements or portions thereof, unless waived intentionally or unintentionally, all designed to ensure against further prosecution double jeopardy, it is the defendant's duty to inform the court of facts alleged for determination of sufficiency to support conviction, should one be obtained. Otherwise, there is no lawful notice, and charge must be dismissed for failure to state an offense. Without lawful notice, there is no personal jurisdiction, and all proceedings prior to filing of a proper trial document in compliance with the 7 elements is void. A lawful act is always legal, but many legal acts by government are often unlawful. Most bureaucrats lack elementary knowledge and incentive to comply with the mandates of constitutional due process of law. They will make mistakes. Numbers beyond count have been convicted without benefit of governmental adherence to these 7 elements. Today, information are being filed and prosecutors by accepted practice rather than due process of law. See Corpus Juris Secundum, Volume 7, Section 4, Attorney and Clients. The attorney's first duty is to the court and the public, not to the client, and whenever the duties to his client conflict with those he owes as an officer of the court in the administration of justice, the former must yield to the latter. Clients are also called wards of the court in regards to their relationship with their attorney. Corpus Juris Secundum assumes courts will operate in a lawful manner. If the accused makes this assumption, he may learn to his determined through experience that certain questions of law, including the questions of personal jurisdiction, may never be raised and addressed, especially when the accused is represented by the bar. Sometimes licensed counsel appear to take on the characteristics of a fox guarding the henhouse. Jurisdiction, once challenged, is to be proven, ladies and gentlemen, not by the court, but by the party attempting to assert jurisdiction. The burden of proof of jurisdiction lies with the asserter. The court is only to rule on the sufficiency of the proof tendered. See McNutt versus General Motors Acceptance Corp., 298 U.S. 178, 1936. The origins of this doctrine of law may be found in Maxfield versus Levy, 4 U.S. 330, 1797, 4 U.S. 330, DALL, 2 DALL, 3812 U.S. 381, 1 LED 424. I will post this on Facebook for you guys to review. Thank you for watching this short video. I have reached my capacity of 5,000 friends. If you would like, you can follow along with me. We always encourage followers. For those of you fortunate enough to be within the 5,000, thanks for participating. And Join us next time.